Happy Friday, and thank you so much for joining me for this week's Cloud Title Tip of the Week. Today, I want to talk about vesting, and this is something that as a buyer agent, you really need to discuss with your clients, and we see a lot of confusion around the subject. In the state of Florida, when it comes to individuals, not corporations or trusts, but when it comes to individuals, there are really only three types of vesting. There's tenancy in common, there are joint tenants with right of survivorship, and then there are tenants by the entirety, which is a married couple that own a property together. And tenants by the entirety is also joint tenancy by right of survivorship. Sometimes a deed may spell out tenants by the entirety. Sometimes it may just say a married couple or husband and wife, which equals tenants by the entirety. And tenants by the entirety, the significance of that is that it affords creditor protection in the state of Florida. Anything that is owned as tenants by the entirety by a married couple is immune from creditor attack by a creditor that has a claim against just one of the parties. But getting back to the vesting, tenants in common versus tenants with right of survivorship. Huge difference between the two. And we get a lot of confusion about that. Tenants in common, as opposed to tenants with right of survivorship, joint tenants with right of survivorship, do not automatically confer ownership to the other party or parties in the event of a death. So if multiple parties, let's say 2 or 3 or 4, own a property as joint tenants with right of survivorship, if one of these people passes away, then automatically everyone else that's left owns the property. There's no need for probate or anything. Also, the interest is considered joint interest, meaning that all the parties have to join in to sell the property. So if you and 2 other people own a vacation property as joint tenants with right of survivorship, for example, then one of you couldn't just go ahead and sell your interest in that property without everyone else. The entire property has to be sold together. Now, tenants in common is very different. Each party owns a undivided interest in that property, and so each party owns an interest in the property. So it could be 50-50, it could be 60-40, it could be 30-30-40, and each of that ownership interest is its own ownership interest, meaning, number one, if I owned a vacation property with 2 other friends as tenants in common, I could decide to sell my interest, my share, to someone else without their permission or without their consent. So I could find someone else that wants to own a third of a vacation rental and sell my interest to them. Number 2, if I were to pass away, then my interest would be part of my estate. So it would have to go to probate. The other 2 friends of mine that own the vacation property with me would not automatically own that property. My will would determine who is going to inherit my share of the property. And to that end, when we have a scenario where a property was owned by tenants in common and one of those people passed away, then probate has to be opened for that ownership interest. So they're totally separate ownership interests and treated separately. When do people choose one over the other? I'm not an attorney. I don't want to give legal advice here. And this is something where your clients may need to consult with an estate planning attorney. Generally speaking, 2 people that have the intention that the other person owns the property once they pass will use joint tenants with right of survivorship. And we see that often with people that are not married, or maybe parents and children owning something together. Tenants in common is a different situation altogether. Again, it's important that you discuss this with your clients if you're a buyer agent or if you are a buyer. And if you're not sure, contact me. I can email you some resources to attorneys that have explanations of these. And if you're not sure, again, this is something where you want to have a conversation with an estate planning attorney or real estate attorney to advise you which would be better. And it's really going to be determined by your financial plan and your estate plan with respect to which of those two would be better. Now, if you are a married couple, can you own property as tenants in common? Absolutely. Happens all the time, especially people getting remarried later in life in their 50s, 60s, 70s. They may want to have their interest go to their children or what have you not. So even if a married couple wants to own property as tenants in common, it can be done. We see it all the time, but we obviously need to know about it. So again, I hope you found this helpful. If you have any questions, please feel free to reach out to me. I'll be happy to put you in touch with someone. We have 3 attorneys that are associated with Cloud Title that I can have you chat with. Or if you have an estate planning attorney, reach out to him or her and get advice on how you should hold title. And as a listing agent, when you pull the vesting deed before you take your listing, and if you can't find that, contact us. We'll be happy to pull it for you or point you in the direction. But you want to look at that vesting deed and make sure, how is this property owned? We have seen scenarios where husband and wife own properties as tenants in common. One of them passed away. The realtor thought, oh, it's just right of survivorship. The other person owns it. And that was just not the case, because tenancy in common is handled and dealt with very differently from tenants by the entirety or tenants with right of survivorship. Hope you found this helpful. As always, if you want to get this in the email box and you're watching this on social media or YouTube, click on the link below. And until next week, I'm Thomas Hyman with Cloud Title. Thank you so much for taking the time.